churches in New Jersey are now eligible for public funding, taxpayer money, and they can use that money to fix up their church. And that seems disturbing. And the reason they can do this is because a federal judge has now ruled that banning money from going to churches for that reason is illegal. You can't not you can't prohibit money going to churches like that. And that's messed up. I'm gonna make sure this is clear to everybody. Okay. So here's the backstory. And I've talked about this, but it's been like a year since I talked about it. So between 2012 and 2015, the county, Morris County, they gave out more than $5.5 million in historic preservation grants. And basically, this is a very old county. A lot of buildings there have been around for hundreds of years. And a lot of these places need to get rejuvenated. They need to fix up the piping and the outside of the buildings and all that stuff. And so the county says you can apply for these preservation grants, right? And it's pretty neutral. Anyone can apply for them. You just got to fill out the paperwork. And between 2012 and 2015, there were churches asking for money because they were like, well, our church building is very old and they're historic. And so we want money to fix them up. And in 2015, an atheist named David Steketee and the Freedom from Religion Foundation, they filed a lawsuit saying, hey, why are you giving money to churches? Because they pointed out that the New Jersey Constitution actually says something about this. This is right in the Constitution of the state. Nor shall any person be obliged to pay tithes, taxes, or other rates for building or repairing any church or churches, places of worship, or for the maintenance of any minister or ministry. No public money going to to support religion in that sense. So the atheist said, it's in there. You can't give money for religious usage. Now, I'm going to cut to the chase here, but like they lost at the district level. It got appealed. Eventually, this case gets in front of the New Jersey Supreme Court. And in 2018, all 7 of the justices unanimously overturned the earlier decision. And they basically said, yeah, it seems like everything these churches are doing is illegal, or everything the county is doing. This is what the justices said at the time. The county awarded $4.6 million to 12 churches to repair active houses of worship. And this is important. We are not giving money. The county was not giving money to churches that existed hundreds of years ago, and there's a historical reason to maintain them as museums, as places people can visit for secular reasons. No, these are churches people are actually going to every week. So why can't the church fund its own upkeep? Why is the city paying for a church to like do some remodeling? It's one thing if the churches were no longer in session, then they're just secular buildings that are in that area. But the Supreme Court of New Jersey said the county gave $4.6 million to 12 churches to repair active houses of worship. And where did that money go to? Roofs, bell towers, stained glass windows, ventilation systems. That's not about renovating a museum. That's about making sure it works for the people who are using it now. And the justices said the use of public funds to pay for those repairs violates our state constitution. So yeah, that's the right move. That is what they said in 2018. And they also noted, this is important, because some of you may be thinking, what about the US Supreme Court? What have they said? Because years ago, the Supreme Court made a decision in a case called Trinity Lutheran. And basically what that decision said is that if the state is giving away taxpayer dollars for ostensibly secular projects, like we're helping renovate playgrounds everywhere, and if a church applies for that grant to renovate its playground, the state cannot say no for religious reasons. You can't say, well, we're giving it to renovate all these other playgrounds, but not yours because you have something to do with the church. That's what Trinity Lutheran said. But the New Jersey Supreme Court said that doesn't apply here because the money was not supporting a secular project that happened to be in a church building. They were just making churches better for the people who worship there, right? And this is what they pointed out. I know this is a different font, but I swear it's like the same decision. The public funds awarded in this case actually went toward religious uses. The churches are not being denied grant funds because they're religious. They're being denied funds because of what they plan to do, and in many cases have done. Use public funds to repair church buildings so that religious worship services can be held there. So basically, the New Jersey Supreme Court said, you're only helping these people remodel their churches. It has nothing to do with a secular purpose. So, like, no, you can't let that lower order stand. So, no money should be given to these churches. That's the bottom line. So, the Supreme Court's decision in New Jersey also said, listen, we're not going to try to figure out which things that got renovated were secular and which things were religious. So, we'll tell you what, whatever money the county gave to the churches, fine, keep it. But moving forward, you can't keep doing that. So that was their ruling. That was a victory for church-state separation. I think it would save taxpayers millions of dollars in the long run instead of using that money to promote religious dogma. Now, there was some other wrinkles in the case, like a group in Morris County asked the U.S. Supreme Court to take up the case, and the Supreme Court said, no, we got better things to do. That's all nice. Even when they said, we're not going to take up this case, like some of the more conservative justices, Gorsuch, Alito, Kavanaugh, they said the only reason we're not taking up this case is because the details are really bad for you. It's so obvious that what you're doing is illegal. You got to give us some gray area to work with. And so we're not taking up this case. But maybe in a different situation, we totally want to help you out. Wink, wink, nudge, nudge. So that's what the Supreme Court said. That was years ago. Now, since all of that happened, it's been like 5-6 years since all of that happened. Two things have changed. And I have to point this out to you. I want to show you this. The first thing, let me see where this is. The first thing is the application process for the historic preservation grants. They actually updated it in Morris County. This is what the application says now. Like, who's eligible for receiving this money? Yeah, well, the property must be located in Morris County. Yeah, that makes sense. 2 is important, 3 is important, but this is new. Look at number 4. Any property that is currently used for religious purposes or functions is ineligible for historic preservation grant funding. They had to add number 4 in there after the New Jersey Supreme Court said you can't give money to churches that are still active. So, yeah, if it's currently being used for church, you're not getting any money. That's a smart thing to do. Here's a more recent change. The number 2, the other thing that happened is that earlier, was it last year or this year? Actually, let me go back. The other big change that happened is that in the years between the last time the U.S. Supreme Court looked at this case and today, they have actually made a couple rulings that change the legal boundaries of church-state separation. The cases are Espinoza and Carson v. Macon, so 2020, 2022. But basically what the court's conservatives said is that if the government's giving taxpayer dollars to any private institutions, you can't not give it to private religious schools and things like that. So they kind of broadened what taxpayer money can go to religious institutions. It's made it easier for religious schools to get access to taxpayer money. And so here's what's happening now. After those 2 cases were decided by the U.S. Supreme Court, a couple of churches in Morris County said, let's see if we could get this case back up to our friends at the Supreme Court. So this is what they filed. This is from Mendham United Methodist Church. This is their actual application from 2022. I blocked out their address and personal contact information, but look at what it says for number 4. What type of organization are you? And they make very clear, not only are we a church, but we're a church that is currently used for worship. Like, they want to make it very clear that they are not going to get this money And when the county says no to them, they are 100% going to sue over this, right? You see how this is happening. So their application's like, yeah, we're doing the thing you say we can't do. We're doing it on purpose. And then later in this application, what do you want the money for? And look what they say. The church needs windows re-leaded. We need a new roof, bell tower changed up. We need a new chimney, furnace, repaving of the parking lot. This is all stuff they need in order to make it more accessible for the people who are going to church there now. This has nothing to do with, we want to preserve the building so that generations of people in Morris County can one day visit it and, take pictures outside of it, whatever. It's very clearly, hey, some of our pipes are broken, and instead of using money from tithes to fix it, we just want the taxpayers to fund it, because screw them. We're going to use our money for proselytizing instead of fixing our building. Now, they're not the only church that did this. Another place called Zion Lutheran Church did the same thing. And both times, guess what? Morris County officials said, yeah, we can't give you money. Our hands are tied. Look at the revised rules. You are used as a church, so we can't give you any of this grant money. So as expected, those two churches filed a lawsuit against Morris County, and they cited the Supreme Court's recent rulings. They actually said in their complaint, they cited Brett Kavanaugh, and they said, simply put, excluding otherwise eligible religious organizations from public benefits solely because of the organization's religious exercise is pure discrimination against religion. And here's the thing. Last week, the reason I'm bringing up this story is last week, a federal judge, gave those churches exactly what they wanted. This is Judge Evelyn Payton. She is a Biden appointee as well. She's not some MAGA cultist. She ruled in favor of the churches. She said, listen, the Supreme Court, I'm going to come back to this in a second. She said, the Supreme Court has kind of tied my hands on this. They say if you're going to give grants to old buildings, you can't not give grants to certain old buildings just because they're being used as churches. So that's what she has ruled. She says the application rule that says no active churches can apply for the grants, that rule is illegal. That's what her decision said. Now, it doesn't mean every church that applies is going to get funding, but that the county cannot say no to them by pointing to that rule and saying, well, you're an active church, so we are going to say no to you. They got to come up with a better reason if they're going to do it that way. But Payton also pointed out in her ruling, this is a very slippery slope. And look at how she put this. For example, one of the churches, the Methodist Church, plaintiff Mendham, the church, they seek to reshingle and paint its bell tower. The sound of church bells instinctively brings to mind a call to Christian worshipers to convene. The other church wants to repair their stained glass windows. Stained glass in churches often reflects Christian iconography. And if you're making taxpayers pay for stuff that is only there not to keep the buildings alive, but because it promotes Christianity, you're basically charging taxpayers to promote Christianity. And look at this. At oral argument, counsel for the churches conceded that if I side with them, if the court sides with them, it is possible taxpayer funding could be used to fix up pews that have segregated, gendered seating. So not only would taxpayers be fixing up churches, they would be fixing up things that help maintain some kind of segregation. And look at that last line right over here. Naturally, the court is concerned with such a broad interpretation, which is quite the understatement right there. So that's disturbing. She also said, look, the state can reject grants that support purely religious iconography. But right now, she has to rule in these churches' favors because they were told no because they're active churches. She says you can't do that. Figure out a better reason. I don't know what happens from here. Barring a change in the application process, these churches can apply for these grants. Like if a historical museum with needs to fix its pipe can get money. A church that is active with broken pipes can get the money, or at least they're eligible for the money. And that also means that all the money that churches save for maintenance of the buildings can now be shifted over to trying to convert people for Sunday school, what have you. And that means taxpayers in Morris County, New Jersey, could now be on the hook, maybe for millions of dollars, for helping maintain older churches that are still being used today, even if that money is being used to support faith-based discrimination. Very, very disturbing ruling. I don't blame the federal judge. I blame the US Supreme Court, but this is where we're heading when Republicans keep nominating and confirming right-wing judges. I did ask David Steketee, one of those atheists who filed the lawsuit years ago, what did he think about all this? And he just told me it felt like a disturbing trend. He told me, we've gone from not funding religious instruction and barring taxpayer subsidies for construction at church-related institutions to requiring funding for parochial schools in some cases, and now potentially requiring funding directly to churches for building repairs. And he told me it would just represent yet another chip in the wall of separation. So I will stop there for questions before I move on. What other questions we got here? So wait, if I have a playground on my private property, can I get my yard renovated? Churches are private land, so if having a playground is standard for renovations, why can't I have the same? It depends on the rules. If anyone is eligible to get their playgrounds renovated and you're eligible by the rules, then yes, the conservatives' argument is, well, then churches can apply for it too. I think the application in Morris County had very specific things, like you had to be on the registry of historic buildings and things like that before you could be eligible for receiving any of this. So I don't think your private playground would count. But again, this is the thing, like if you have rules of any kind, you can't exclude people because of their faith, or at least not for that reason alone. So one side of this says you just got to find a better reason to say no to them. The other side says, too bad, just give churches money. They're eligible for it. They could receive it. I'm also not a lawyer. I don't know why anyone's listening to me. Yeah, so a private corporation can apply for public funds to replace their headquarters roof. In the case I'm talking about, if it's a historic building and there's a reason it needs to be renovated, then yes, that's the situation in Morris County, because what they're saying is we just have a lot of old buildings here. We want to maintain them. Let's try to help our community maintain those old buildings. So if a private corporation is using a very old building, I think, yes, they could be eligible in certain situations to get that cash, and so can churches. How about you don't pay taxes? Piss off. That would be the correct answer. Like, these churches are not paying anything into the system. I don't know why they're eligible for it. But again, this is the sort of thing the county could put into writing. Like, it's eligible for taxpayers, but then nonprofits that work in a historic building would not be eligible. Like, again, it depends on how you want to parse these rules. What if the building is an active brothel or gambling club? I love these hypotheticals. How would those Christian taxpayers feel like that? If we converted that Noah's Ark from the other story into an active brothel, how would Christians feel about that? At that point, it doesn't matter. Like, again, just to take your hypothetical seriously, I'm sure some of those people would be mad. I mean, people are always mad at where their tax money goes. The question is, are the rules being applied fairly? In this case, the Christian argument is no, they are not. And for now, a judge has said, yeah, you're right. No, they are not. So that's why the decision is what it is. They don't pay taxes, but they charge the people in the pews 10% to fund the ministry through missions, community outreach, and general maintenance of the building. Yeah, that's what the money should be going for. And now they can just take that bucket of money and put it towards other stuff because they don't have to worry about maintenance. Taxpayers are funding it for them. That's disturbing. Like, if you're a church, why do you even want taxpayer money to fund a lot of this stuff? Aren't you better off not doing that? All right. Thank you for that. donation. So I need a new, bigger wood shop. What if I hung a cross and posted it on Twitter? Can I apply? You're not a historic building. You're not eligible for it. You will just have to build a bigger ark, and then maybe good things will happen.